Dear aspirants, Environmental Protection Act of 1986 is one of the focus areas of UPSC. Frequently, the questions have been asked about the act, the provisions of act, or the institutions which are created as part of the act, and the rules which are enacted with regard to this act, and also certain things which are ongoing, which are in the current affairs, are also related to Environment Protection Act. Through the analysis of previous year questions and learning about the important provisions, let's comprehensively learn about the Environment Protection Act and its relevance to the upcoming prelims. So here let's start with solving a previous year question only, and the importance of previous year question itself, how we get clues with the previous year questions in prelims examination hall, how those questions comes handy. So when I encountered this question in 2022, which one of the following has been constituted under the Environment Protection Act of 1986? So unless we know the particularly or the specific fact which of these bodies are constituted under this act, it is very difficult to answer this question, because even if we do some guesswork, there is only 25% of probability of getting it right, because it is A, B, C, D. If we are just guessing the answer, then we are risking. So here, but in 2022, one of the previous year questions itself came to my rescue in examination hall. So I would like to point you directly to this particular question of 2020. So here about Central Groundwater Authority, in 2020 itself UPSC had asked this question. Consider the following statements. Here the first option the first statement talks about some classification made by this Central Groundwater Authority, but look at the second statement. Central Groundwater Authority was framed under Environment Protection Act. When I had analyzed this question, 2020 question, then I exactly remembered that Central Groundwater Authority was mentioned in one of the previous year questions, that is in 2020, and the fact that it was formed under the Environment Protection Act, it directly helped to solve this question. Then it was easier to arrive at the answer that the Central Groundwater Authority was constituted under Environment Protection Act, with the understanding of this particular question of 2020. So now let's learn about this Environment Protection Act comprehensively. Then we will also come back and solve certain questions of previous year questions. So let's learn about Environment Protection Act. If we analyze the background of this Environment Protection Act, so it was enacted at the time period of 1986. By this time, there were certain legislations like the Water Prevention and Control of Pollution Act of 1974 or Air Pollution Act of 1981, but they were not much comprehensive. And by this time, Constitution of India was also amended to include certain provisions like Article 48A of Directive Principle of State Policy. And environment protection had become a kind of movement, and it had also become part of fundamental duties of as part of Article 51A. And by this time, Supreme Court also, in number of judgments, including MC Mehta case, it had recognized right to clean environment. Right to environment is part of Article 21, that is right to life and personal liberty. And in the international or global level also, environment problem had come to forefront. By this time, India had was a signatory to Stockholm Convention of 1972, which recognized that the countries should enact or legislate on environment protection. So in order to implement this particular act, in order to implement this particular act, Parliament used the power under Article 253, which gives power to Parliament to legislate on any issue covered by international treaty, which was signed by India. With regard, in 1986, Parliament had enacted this act. So this act comprehensively it starts with defining certain terms. So if we see, it comprehensively defines certain terms like environment. Environment includes water, air and land, and not only the abiotic factors but also the biotic factors, living creatures, human beings. So it environment comprehensively covers all these beings and the interrelationship which exist among these. And then it also defines environment pollution. It also has the broader definition about the environment pollutant, that it could be solid, liquid, gaseous substance which in such concentration as maybe it is injurious to environment. And it also defined environment pollution means the presence in the environment of any of these environment pollutants, which is defined in the act itself. And then handling of these substances, certain substances, storage, transportation and transfer of those substances. And it also defines what are the hazardous substances, what might be considered as hazardous substances which cause harm to human beings and other living creatures and also to environment. So these are the certain important terms which are defined in this act. And other than these definitions, it also empowers central government. It is centralizing certain powers in the hands of central government to take measures to protect to protect and improve the environment. With regard to this, it also empowers central government to create certain authorities, certain institutions, and also it gives power to the central government to appoint officers in these institutions, and it the power to give directions. And also the central government can make rules to regulate environmental pollution. In a while we will look into the facts that which are the rules which are enacted in this act. Other than this, prevention, control and abatement of environmental pollution, it has detailed provisions for prevention, control and abatement of environmental pollution. In this regard, it talks about the penalties, what are the offenses by companies, government departments, and it defines certain things which are related to this. And in the miscellaneous provisions also, it has details about the cognizance of offenses and bar of jurisdiction of the courts into the actions or the rules made by the central government in the implementation of this act. And then it has power to make rules. Clearly it empowers central government. Most of the power has been vested into the hands of central government. So this is the brief thing which we can learn about this act. The most important things which we have to remember with prelims point of views are the which are the rules enacted, which are the rules which have been notified by the central government for the in relation to this act, and the institutions which are created and why they are in current affairs right now. So if we look into the particular rules which are created under this act, first and foremost it is the environment protection rules itself. Just after the enactment of this act in 1986, environment protection rules was notified, and under this genetic engineering appraisal committee was constituted. And then there is this institution, that is Central Groundwater Authority also. Presently it is under the Ministry of Jal Shakti, which was also asked in prelims in 2022 and 2020. So this is also an institution which is created under this act. And then there are number of rules which are notified. That first is the solid waste management rules, notified under this particular act. Plastic waste management rules, the recent plastic waste management rules was enacted in 2022. And biomedical waste management rules, e-waste management rules, considering that we are generating millions of tons of e-waste in the recent times, be it in the form of electronic gadgets, or and also in the attempt to switch to renewable energy, the solar power generation using solar energy also generates a lot of e-waste. So in this regard, e-waste management rules comes into prominence. And then wetland conservation and management rules, uh, coastal regulation zone rules. These are the important rules which are notified under this particular act. And there are also certain notifications, guidelines which are issued time to time under this act. One such notification is the environmental impact assessment, and also the guidelines for enacting coastal eco-sensitive zones. Eco-sensitive zones is also in current affairs with regard to 2023 Supreme Court judgments, that Supreme Court had issued an order that areas in and around the protected areas, at least 10 kilometers should be notified as an eco-sensitive zone, so that they act as buffer for the protection, and a kind of it creates a wildlife corridor, protected zones for the migration of animals, and also it reduces man animal conflict. And then Supreme Court, there were huge protests and the things like that, and Supreme Court in June 2023 again it relaxed the its opinion on the eco-sensitive zones. So this eco-sensitive zone is also in current affairs. And examining the remaining current affairs, we have already dealt with the previous year questions of 2022 and 2020. In 2019 many questions were asked, 4 questions were asked which are related to this particular act. See here in 2019, Environment Protection Act 1986 empowers the government of India to the first statement, to state the requirement of public participation in the process of environmental protection and the procedure and manner in which it is sought. No, this particular statement is wrong, because this particular act doesn't talk about this public participation. Mainly it emphasizes on the power of government of India and enacting the rules with regard to the environmental pollution, but it doesn't talk about the requirement for public participation. And then it lays down, empowers the government of India to lay down the standards for emission or discharge of environmental pollutions from various sources. Yes, this has been given in provision of this act. So the answer is B, 2 only. And then solid waste management rules, as we discussed, just discussed this particular rules. Why I have put here, because this rules was enacted under Environmental Protection Act. So this rules, it talks about waste generator has to segregate waste into not 5 categories but 3 categories. So this is a wrong statement. The rules are applicable to notified urban local bodies and notified towns and all industrial townships only. No, this not only the urban areas and towns, but this rules is applicable to rural areas also. So this only is making this statement wrong. If it had given that the rules are applicable to so and so, like the urban bodies and notified towns, it was right, but it is not limited to those. The rules provide for exact and elaborate criteria for the identification of sites for landfills and waste processing facilities. Exact and elaborate criteria, don't you think so that this is making this statement very extreme? Any rules, does it talk, can it give some exact and elaborate criteria for identification of something? This is also a wrong statement. It is mandatory on the it is mandatory on the part of waste generator that the waste generated in one district cannot be moved to another district. So this is sorry for this mistake, this is the wrong statement, and the third statement, or the C is the right statement, that the rules provide for exact and elaborate criteria. So I'm correcting my mistake, that the act cannot produce, the act itself cannot produce for the detailed or exact and elaborate criteria, but the rules can speak, because rules are rules are specific, they are the delegated legislation. The executive are the one, executive is the organ or the executive body notified the rules in general also, not only with the solid waste management rules or environment protection act. In general also, the rules are the one which are very specific. Acts or the legislation are generic, but the rules will be elaborative and they are specific. So C is the right answer for this. And then extended producer responsibility. The principle of extended producer responsibility, or Environment Protection Act not only talks about the extended producer responsibility, it also works on the principle of polluter pays principle, right? That also you have to remember. Extended producer responsibility, in this given option, it concerns with the e-waste rules, e-waste management and handling rules, that the producers of the e-waste or the electronic waste, they are mandated to deal with the e-waste. And this extended producer responsibility not only with the e-waste but also with respect to the plastic waste management rules also, this extended producer responsibility comes into picture. So this is one thing which you have to remember. And then about the Ramsar Convention. Ramsar Convention, it is mandatory on the part of the government of India to protect and conserve all the wetlands in the territory of India. It is the duty of government of India to protect and conserve wetlands, but it is not mandatory under Ramsar Convention. Any convention it is not practical to make an international convention cannot make any sovereign government to do something mandatorily. With that common sensical knowledge also, we can easily say that this statement is wrong. So I am cancelling this A and D. By this we understand that this third statement is right, that the wetland rules of 2010 also encompass the drainage area or catchment regions of the wetlands as determined by the authority. Yes, this is a correct statement. But the second statement, we have to examine the wetland rules were framed by the government of India based on the recommendations of Ramsar Convention. There might be some influence of Ramsar Convention with regard to the conservation and management, but we cannot say that government of India, it is based on the recommendation of this convention. We cannot say, because Ramsar Convention is an international convention and it will be much more generic when it comes to the conservation and management. And under Ramsar Convention, many Ramsar sites are notified, are identified, and certain funds like the Nagoya Fund will be made accessible for the conservation of those wetland areas. But that is completely different. But this is a wetland rules is enacted, and the implementation of these rules is made by Ministry of Environment and Forests. It is not completely based on the recommendations of Ramsar Convention. This is a wrong statement, and the answer is C, 3 only. And then this particular question was asked in 2015. The Genetic Engineering Appraisal Committee is constituted under the rules of genetic, there is a rules which has been notified with respect to the regulation of genetic engineering or genetically modified crops. Under that, this particular committee, that is Genetic Engineering Appraisal Committee, has been constituted, and it is under the Environment Protection Act of 1986. This particular question is relevant even now because there is a lot of ongoing things with respect to the introduction of genetically modified crop, that is Dhara mustard 11 Dada mustard hybrid 11, that is the GM mustard. With respect to the controversy of GM mustard, Genetic Engineering Appraisal Committee holds significance for our upcoming prelims. And then this question with reference to eco-sensitive zones, which of the following statements is or are correct? Eco-sensitive zones are areas that are declared under Wildlife Protection Act. No, it is not under the Wildlife Protection Act, it is under Environment Protection Act of 1986. The purpose of declaration of eco-sensitive zone is to prohibit all kinds of human activities in those zones except agriculture. So prohibition of activities is done, but mostly it is the regulation than prohibition. And we cannot say that the one size fits all, that all kinds of human activity is the extreme thing which is making this statement wrong. All kinds of human activities except agriculture, we cannot say that, because the declaration of eco-sensitive zone will be done by the local forest department or the regional forest department, the state forest department. They will identify with the collaboration of a committee which will be constituted for this purpose. They will identify what kind of activities have to be regulated, what kind of activities have to be prohibited. Along with agriculture, there's some certain activities like tourism, horticulture, they can also be regulated, not completely prohibited. So this approach of one size fits all makes this statement wrong. And I am again reiterating that eco-sensitive zones is again relevant for the upcoming prelims because it is in current affairs. In 2023, Supreme Court has passed orders regarding to eco-sensitive zone, and there is also Kasturi Rangan Committee report. There is the implementation of Kasturi Rangan Committee is a controversial aspect, or there is ongoing things which are related with the Kasturi Rangan Committee report or Madhav Gadgil Committee report, which talks about the declaration of certain areas of Western Ghats as eco-sensitive zones or eco-sensitive areas. So with that, keeping those things in mind, this question becomes important and important areas of focus for UPSC. And then this particular question was asked, Animal Welfare Board of India is established under Environment Protection Act. No, this is not established under Environment Protection Act, but it was enacted, or it was established under Prevention of Cruelty to Animals Act. So this is a wrong statement. So dear aspirants, with this we have comprehensively covered the important aspects which are relevant to the Environment Protection Act, and I hope that this information, these learnings gives you some hints in the examination hall in the upcoming prelims, and if you get such opportunities or such questions, please make use of it. And if you are liking these contents, please subscribe and comment your feedback. Thank you.